This present lecture will discuss regarding indecent representation of Women's Prohibition Act 1986. So, this act prohibits indecent representation of women through advertisement or in publication or writings or paintings or figures or in any other manner, and the matters connected therewith or incidental thereto, as per the provisions under the Act and as the very objectives of the Act is relating to advertisement, publication, and writings, paintings, and figures, and etc. In that connection, we would like to discuss the then existing provisions. The law on obscenity is codified in sections in the Indian Penal Code as per the provisions under Section 292 to 93 and Section 294 of the Indian Penal Code. Despite these provisions in publications, especially in advertisements, there is a growing indecent representation of women or reference to women, which has the effect to degenerate women, but is also derogative of women, while there may be no specific intention. These advertisements, publications, etc. have a depraving and corrupting effect. A different legislation was therefore necessitated to legislate to prevent the indeterminate representation of women effectively by means of advertisements, books, and pamphlets, etc. So, in that connection, now we would like to discuss the various provisions of the Act relating to indecent representation of women. Prohibition Act of 1986. So, in that connection, we would like to discuss the various provisions as per Section 3 relating to prohibition of advertisement, but exactly what advertisement as it is defined under Section 2 relating to indecent representation, and what exactly advertisement means. So, as per the provisions of under Section 2, indecent representation of women means the depiction in any manner of the figure of a woman or form of body or any part thereof in such a way as to have the effect of being indecent or derogatory to or degenerating women is likely to deprave, corrupt, to injure the public morality or morals. And as per the definition of advertisement as provided under Section 2, it includes any notice, circular, label, warfare or other document, and also includes any visible representation made by means of any light, sound, smoke, or gas. And now we would like to discuss the provisions of Section 3 relating to prohibition of advertisements. So it prohibits advertisements containing indecent representation of women, and Section 4 provides for prohibition of any kind of publication. So it prohibits publication or sending any post of books, pamphlets, etc., containing indecent representation of women. And as per Section 5 of the Act, it is relating to power to search and seizure, and such provisions also we found as per the provisions of Section 94 of the Criminal Procedure Code. So the gazetted officers, as per the provisions under Section 5 authorized by the state government, are empowered to enter and search within the local limits of the area in which such officer is authorized at any public place, but a warrant is required for search of a private dwelling house. Such officer may seize any document, etc. Regarding that, the provisions of the Code of Criminal Procedure as provided under Section 94 of that Code is applicable relating to search and seizures, and Section 7 in particularly relating to Section 6 powers for penalties. So, it provides penalty for contravening the provisions of Section 3 and Section 4 to be punishable for the first conviction with imprisonment extending up to 2 years and with fine extending to 2,000 rupees, and for the second or subsequent conviction with imprisonment for not less than 6 months but extending up to 5 years, and with fine not less than 10,000 rupees but extending to 1 lakh rupees. And now we'll discuss the provisions relating to Section 7, offences committed by companies. So, it provides for offences committed by companies. So, also under Section 8, it provides that such offences are cognizable but are bailable. So, offences made under the provisions of this Act are made cognizable but bailable. And as well, Section 9 of the Act provides as action taken by such officers as actions taken in good faith. So, all actions taken by those officers, such as those gazetted officers, such actions would be considered as taken in good faith, and they are protected under the various provisions of the Indecent Representation of Women's Prohibition Act 1986. And as regarding Section 10, it relates to rule-making power, and such rule-making powers entirely lies with the central government as per the provisions of the Act. So now we would like to discuss the Indecent Representation of Women's Prohibition Bill as framed in 2012, which seeks to emphasize the inclusion of women in the audiovisual, visual and electronic communications media, and to address the issue of female objectification, in addition to ensuring a media coverage in all its aspects of regulatory structure implemented in law. The law also lays down a stringent compliance mechanism to behave in a dissuasive way in which any indecent behavior which contradicts the law is prohibited. Two major changes introduced under the Indecent Representation of Women Prohibition Bill of 2012 are those, and what advertisements will fall under the scope of the bill if it is passed, and also what will lead to delivery to warrant the punitive provisions of the new regulatory framework under the amendment. The proposed regime was specified in such a way as to include print and digital media as well as electronic delivery modes of such content. And now we would like to conclude our lecture on the very act, Indecent Representation of Women, Prohibition Act of 1986. So, there is no question that the Act has established women's indecent representation, but that description is not exhaustive. It left open to interpretation by the courts. It is a successful law for maintaining women's integrity and upholding their reputation, but their success depends on their implementation. The powers conferred on any gazetted officer under the Act to such and such indecent material resulted in extensive corruption. Moreover, the penal provisions are not strict in nature. The quantum of fine is way lesser as well as punishment for the repeated offenders. On the other hand, if Section 292 of the Indian Penal Code is intended to limit and control of sensitive and indecent representation of women, the expression of other general objects of concern must be removed from the derogations. Thus, there is a need for stringent provisions required to manage the indecent advertisements, publications, and representation in any manner of a woman, either by writings, paintings, figures, pamphlets, etc., must be strictly prohibited, and stringent actions are needed from the authorities under the various provisions of the Act, in particularly relating to the power to search and seizure as provided under Section 5 of the Act, as per the provisions under Section 94 of the Criminal Procedure Code of 1973, and also the very need for stringent actions by the authorities relating to the penalties for those offences committed under the Act. And also there is a need to rethink about the provisions as provided under Section 8 of the Act relating to if the offences are considered cognizable, but it must not be bailable. So, there is the urgent need to think and to rethink about the very changes to be made to the 1986 Act, as such the Act is Indecent Representation of Women Prohibition Act, to strictly follow those moral codes relating to advertisement, publication, writings, paintings, pamphlets, figures, etc., either in the print media or in the digital media or electronics media.